One thing we did, and I think appropriately, is we started with the great work product that was done in the 1980s by the prior version of the Restatement of Foreign Relations. And where that restatement stated things well enough or could be improved through just drafting amendments, we did that. We were all found that a lot of the old restatement, in fact, was quite useful. A quarter of a century had passed since then, and so a lot of case law and statutory law and other developments had occurred, and so we knew we had to update some of the things that the last restatement addressed. It also turns out there were just some new issues in the law that the people working in the 70s and 80s couldn't have anticipated reasonably, and so those were new areas of terrain, including, of course, changes in the statutory law that Congress has added since the 1980s. And that may be particularly true in the area of immunity, but it's true to some extent in all of the three subject areas of the restatement.
But at the upcoming annual meeting, they'll see a section that we've discussed and they would have seen prior drafts of concerning self-execution of treaties. They will see some that concern the relationship between treaties and federalism, something that has had a high degree of political valence in the past. And they'll also see a section that they have not seen directly before concerning the termination of treaties, among others. And so they'll see sections that both attempt to describe how treaties are made, what their immediate import is under federal law, and also their relationship to other parts of the Constitution. So it really covers a very wide range of the kinds of treaty topics that practicing lawyers in the field would see.
There's also the issue of involving, in certain areas, questions of international law, because we're not the only country in the world that has to deal with these. In fact, while I think we have more cases in our courts than any other country, countries increasingly now have to deal with this problem. They look to our U.S. law. So we look not only for the text to give guidance to litigants and to courts, but also to some extent to foreign governments. A number of the questions are quite challenging. In the area of commercial litigation, commercial activity, which gives the most number of cases, exactly what the terms mean and how they're interpreted has been challenging. Some areas are unique to the United States. For example, the state-sponsored terrorism area, which has generated quite a bit of litigation, and other governments looking quite interested in how we deal with that.
Well, it's probably true that the stuff that's done last has been the hardest. So there are some technically challenging and maybe policy challenging pieces of it. And there's a lot. This will be the largest package we have given the annual meeting. I can't point to one rather than the other and say this is what you ought to pay attention to. I mean, I think it all works together. And we bridge a lot of topics. I mean, just within jurisdiction, for example, we have 4 different pieces dealing with 4 different problems.
There are 2 pieces on jurisdiction to prescribe, that is, the jurisdiction to make law, one of which has actually already been approved on the presumption against extraterritoriality, but the Supreme Court came down with an important decision that we had to incorporate, so we're bringing that back. And then there's another provision on interpretation that was developed later in the process on reasonableness in interpretation. It's sort of a supplement to the presumption against extraterritoriality, and the membership will be seeing that for the first time. Then there are provisions on jurisdiction to adjudicate. We've done the civil side of that, but now we've got 3 sections on the criminal side, on the fact that a criminal defendant has to be present in the United States to be tried, on the fact that we generally get someone's presence through extradition, and then a section on mutual legal assistance treaties. And finally, we have a few provisions on jurisdiction to enforce. That is, the authority of a country to enforce law, I guess to use its power to enforce law. And we talk about U.S. practice, we talk about international law, and then we just couldn't resist adding one more section on the enforcement of foreign judgments. So there will be a lot for the membership to consider.